Okay, good afternoon. We'll call the meeting to order. If you could please stand for the pledge. I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, this is the Town of Riverhead Planning Board meeting. Today is Thursday, August 19th, 2021. A few discussion items to start with today. The first one is Rosenbaum Beach Stairs at Chapter 219 permit. Greg?
All right. Thank you, Mr. Chairman. So I did speak with the applicant. He was unfortunately unable to make the meeting, but he said to go forth with the presentation. So this is a Chapter 219 Coastal Erosion Hazard Area Permit application seeking approval to construct an 83-foot-long set of beach access stairs with landings and to install a 16-foot set of aluminum flip-up stairs and an access platform. Subject property is located at 2300 Sound Avenue in Calverton within the RA40 zoning district. Property is presently improved with a 2-story single-family residence and an armor stone rock revetment at the toe of the bluff. The proposed beach access stairs are accessed on the property via a dirt path which winds through the property. There's no improvements currently proposed to that footpath. The proposed action is an unlisted action pursuant to SECRA, with coordinator review being optional and not recommended. The applicant has obtained a valid New York State DEC permit for the proposed action, and the town's consulting engineer has taken no objection to the project. At this time, staff recommends the planning board assume lead agency status without coordinator review and issue a negative declaration pursuant to SECRA. So the planning board had recently reviewed a Chapter 219 application on the subject property for the installation of that rock revetment system located at the toe of the bluff, as well as to perform bluff terracing and vegetative plantings along the face of the bluff in order to help limit erosion. That prior approval was granted by the planning board on April 1st, 2021 by resolution number 21-033. At this time, the bluff terracing and plantings have not yet been installed. This work will be completed after the installation of the beach stairs proposed under this current application. The rock revetment is done, but the bluff terracing and planting has not yet been done. It wasn't appropriate. I did speak to Vinnie Gaudiello. It wouldn't have been appropriate to complete that work and then go and do the beach stairs because it would have just gotten ripped up and destroyed anyway. So they do have a valid New York State DEC tidal wetlands permit, which is valid through January of 2026. In a memo dated August 4th, the town consulting engineer took no objection to the proposed beach project, but he did recommend, prior to engineering approval, the length of the support post, the buried depth of the supports for the stairs should be annotated. I have since received revised plans. They show a minimum buried depth of 5 feet. I did refer them back to Vinnie, and he took no objection to the 5-foot buried depth. The plans state that there should be no staging areas required for the installation of materials. However, the plans do identify that if they did need to have material storage areas, there is sufficient area on the subject property to where it would not prohibit public access to any beach. And the applicant's contractor has already entered into a hold harmless agreement with the town attorney's office. That was executed on April 12th of this year. I did speak with the town attorney's office. They will just need to amend that hold harmless agreement to reflect the approvals granted under these current beach stair applications.
Greg, the proposed work, is that just on the lower portion of this? Because it shows up by the house that the walkway or dirt path goes onto neighboring property?
That dirt path does wind across the neighbor's property. I did speak with the applicant. His neighbor is actually Councilwoman Kent. They have an agreement where they're going to both be able to use that stairway. But that footpath is an existing footpath, does go onto, it's kind of like a 9-foot wide right-of-way. That would be used as future beach access to another parcel. But that's an existing winding footpath, and there's no improvements proposed to that area.
Okay.
Right, when the flip-up stairs go down to the beach access, is that still on their private property?
Yes, sir.
Not public property?
Yes.
So Greg, are you saying that it transverses from the subject property across another property and then back to the property?
The winding footpath, yeah, I believe it does cross a property line, but they seem to be in agreement. I mean, if they needed to, if there was ever some sort of disagreement, they could come to the board for a, modified footpath, but it's an existing footpath. It looks like it's been there for quite some time.
Do we want to cover ourselves in again?
Well, but that's what I was asking, but the
Yeah.
scope of this work is not being proposed for that
Correct,
footprint.
correct. No
so it's only on
modifications.
their property.
Correct. The beach stairs are solely on this subject property.
Okay, any other questions? Nope. All right, thanks, Greg. Okay, the next item for discussion is Bating Hollow Farm Vineyard. They're looking to construct an addition to the barn and wine tasting pavilion.
We do have representatives here for the application. As you recall, this is an application seeking approval to construct an approximately 6,000 square foot barn-style wine tasting pavilion with a cellar for winemaking, construct assorted farm structures, including a 2,500 square foot equipment barn, convert an existing wine processing building into a bathroom, as well as perform lighting, landscaping, parking, drainage, and sanitary system improvements. The subject property is located at 2114 Sound Avenue in Bating Hollow. The planning board did hold a public hearing on this application at last meeting on August 5th, at which time there was an issue that was brought up regarding events on the subject property, noise, attenuation. So I wanted to bring the applicants back to discuss, moving forward with the site plan approval. I did speak to the town attorney regarding events and weddings on the subject property. There are, which I did provide to the board in this week's packets, there are provisions within the New York State Ag and Markets Law which allow for certain events conducted in furtherance of a farm vineyard, which Mr. Kelly has provided us with a copy of his license, and he is a licensed farm vineyard. The New York State Ag and Markets Law do allow certain events, wedding receptions, parties, and special events that are used to further the marketing and promotion of the farm vineyard. So the issue of the use, they are allowed to have some events. There are criteria within those Ag and Markets laws which state that it deals with income that's generated from that farm being a certain percentage as compared to the income that's generated from the sale of wines. The Ag and Markets law does state that the Ag and Markets Department will review those on a case-by-case basis. So we will be referring the application to the Ag and Markets Department for some kind of interpretation as to how they arrive at those conclusions. But one of the larger issues came up about outdoor music and potential noise disturbances. So I wanted to invite the applicants here to have a discussion with the planning board to discuss conditions regarding outdoor music. I did look through the town code. There was some mention of sustained, amplified outdoor music meeting certain thresholds of the town code. But then there's a section which refers to live music as being a use associated with a tavern, which this use is not. So I'd like to have the applicants here and.
So at the public hearing, we started the conversation about incidental music outside. And I think that's where we kind of started going in different directions, because at least I was under the understanding that, incidental music did not include outdoor activities or amplified music on a regular basis. However, it may be allowed under a special permit issued by the town board. And I think the applicant had suggested otherwise, referring to some type of court ruling. So that's really what we want to get to the bottom of before we move this much more forward.
So I did have Bob Kozakevich look at the judgments and the court rulings. He didn't see anything where it explicitly allowed incidental outdoor music. I would invite the applicant to, present information to the contrary. He did not see anything that would explicitly allow that in the ruling. So I believe it could be something that could be addressed through site plan review.
Okay, so that is as far as the town's understanding for the court ruling, right?
Correct.
So what about incidental music in general? What is the definition or position of incidental music? Is that just low-volume speakers playing in the background? I wouldn't imagine that includes live bands on every weekend. So, you know, where are we with that? Interpretation or position of the applicant? Yep.
I'd invite him to come up and answer some of these
I
questions.
guess it would fit into what types of activities and stuff like this.
Well, yes, I mean, that deals with the weddings, you know, wedding receptions. I mean, again, I didn't find anything explicitly in our code that deals with incidental music. You know, that phrase is not something that's present in our code. It's almost somewhat ambiguous.
Right. So, the town of Riverhead, can I take a look?
Okay with me.
That's fine.
I just want. So the town of Riverhead brought a lawsuit against the prior owners of the vineyard for a number of causes of action, but the first one was to enjoin and restrain the defendant from occupying the premises for any special events, including where food is being provided, outdoor events, and events with amplified music. That was the cause of action brought by the town of Riverhead. And pursuant to the affidavit submitted by the prior owner in defense of that allegation, the defendant acknowledged providing their customers with recorded and live music, generally from afternoon to early evening on weekends, and offering the use of its facilities for catered private parties such as weddings, anniversaries, birthdays, fundraisers, as well as daily and weekly wine tastings, but contended that none of those activities were considered special events under the town code. And the court said that based on Rich Rubin's affidavit, and as evident by the types of ongoing events described, that they are not forms of public entertainment involving spectators, as the relevant definition would seem to require. And as a result, the defendants were entitled to summary judgment dismissing the first cause of action. The court went on to say that although the town submitted affidavits from local residents and excerpts from the defendant's website calendar showing claims that the defendants used and continue to use future tent sites to erect tents, to conduct events including weddings, events with provisions of food, outdoor events with live amplified music, pony rides, face painting, horse exhibitions, and other events during and on a continuous basis, it has not demonstrated that any of those activities would be found to constitute special events. So, with all due respect to the town attorney, I think it's said pretty clear that those items do not count as special events, which would require town permits in advance.
Well, unfortunately, I think we have to go by our town attorney's opinion on the ruling. So, I mean, Dick, where does this leave us? Because if we're being advised otherwise by our attorney and they're interpreting it differently, I mean,
Well-
where does that leave us?
I get in trouble for not going to the microphone. You want me up here or you want me over there?
Wherever you're more comfortable.
So when Greg called me on this, he said that he was going to refer it to Bob Koskevich. And Bob did write a memo, which I think Greg has available for the board, that says basically it wasn't mentioned in the decision itself. I had suggested to Greg that he contact the applicant and have them forward us the written material that they believed supported their position. I haven't seen anything. The gentleman has raised this today, And I think Bob and I can certainly review his comments and give you a response. I'm not able to just, hear first cause of action was dismissed, therefore we win. I'd have to review the context of that. Happy to give you more information on it. I'm a little, maybe moving off that topic slightly, the role of ag and markets in what constitute farm activities, and then what are protected farm activities, and whether those protections supersede zoning in cases where the zoning is in direct conflict with the prescribed activities. That's a very big issue, obviously, in rural communities like ours. So I'm just not sure that it's as simple as asking the ag and markets people his percentages of income from different sources, and therefore he gets to have live entertainment. It's a complicated question.
Well, my understanding of the Ags and Market Law is that it would only come into play if the town of Riverhead prohibited something that's allowed by Ags and Market Law, and that was addressed in this lawsuit as well. And the court said that there was no prohibition in town code to these events, and as a result, the court didn't even consider Ags and Markets Law at that time, and they said they'd only review it if the town had some law or code prohibiting the use.
So
Which is, sorry, our code is generally a permission code. This or that is permitted in this or that area, and the failure to mention it doesn't necessarily mean that it's permitted because it wasn't specifically excluded. So we'd have to read the code sections that he's citing to understand those particularly.
So you're saying that the town code is permissive-based,
So
but if it doesn't mention it,
the
it's
general-
not permitted?
The general zoning structure is you can have a single-family residence in the single-family residence zone. That the fact that it doesn't say you can't have a pet grooming store there doesn't mean that you can have a pet grooming store in the single-family residence zone.
So there really are two separate issues here, one with the outdoor noise or incidental noise, and one with the events, right?
Yeah, it seems that just to go back to basic principles, the Zoning Board of Appeals is the proper place to resolve confusion or misunderstandings about the specific code involved, and they can go for interpretation. I mean, one simple solution would be to send them to the ZBA for an interpretation, whether the state of facts that they present meet the need for a special events permit, yes or no, in the opinion of the zoning board. And then your board can rely on that interpretation.
But doesn't every other winery do it already? And this gentleman also already has done it? What are we gonna
That
have,
would be
one
part- that would be
winery
part of-
doesn't have music?
Again, that would be part of the proof to be submitted either to your board or to the zoning board.
So,
But that's, there are numbers of Article 78 proceedings that are brought against municipalities when what's permitted in the town is excluded from one individual. And that's just based on an arbitrary and capricious decision made by the town. And like this gentleman said, this is something that's not new. We're not trying to do something new. I mean, obviously, I'm here asking permission to build a tasting house, so we need to address them. But this is not something new that's happening in the town of Riverhead, and it's not just wineries.
well, we're talking about the Sound Avenue corridor, really, and that's what some of the residents had brought up at the public hearing. And someone had referenced the cider house, which was again a discussion, and they agreed what the definition of incidental noise was, and then they agreed to have all of their live music inside, and it wasn't an issue anymore, and we moved that along for them, and they've been great neighbors, as everybody has mentioned during the public hearing. So if you're building this new facility, is all of your music going to be inside?
Not all of it, because, when it's nice out, people are gonna wanna be outside. And like I
Well, I
said,
think
for the last 17 years, they've been playing music outside at this venue, and to be honest, I continue to do it to this day. And I'm comfortable that when it was addressed, the Supreme Court judge took the town attorney's position and the attorneys for Mr. Rubin and went through the relevant town code and said that none of those things specific, weddings, amplified music, anniversaries, live or pre-recorded music, none of them qualified as special events, and dismissed that cause of action against the Rubins.
Well, I think we need to give our attorneys a chance to review it as Dick suggested, and give us their interpretation of it. And then if after that, we want to refer them to the zoning board, we'll do that. But, I mean, where we are right now, I'm kind of hearing different things, and I don't know that we could just move forward as proposed.
Getting back to what Greg said, Greg just said that there was nothing in the decision that allowed us, right? Is that
Well,
what you said?
that was, again, there was no memo, this was based on a phone call
Oh,
with the town attorney.
the town attorney didn't review this
I mean,
case?
he did review it, but I don't have a formal memo, so I
Okay.
spoke with him on the phone. He said he didn't see anything that appeared to allow,
Right.
as you said, explicitly allow incidental
Exactly,
music,
but-
as you say.
This judge was asked to grant summary judgment either way in favor of town of Riverhead or in favor of Mr. Rubin, and they dismissed the complaint. The next sentence wasn't, oh, so he can now have all the weddings and parties and stuff he wants, because that wasn't the question presented to the court. The court was asked whether those events that he admitted to in his affidavit to doing it on a continuous basis, the court said that none of that runs afoul with the town code.
Okay, so we're going to ask Dick and
I'll
Bob.
pass that on to Mr. Kozakevich, and you or your counsel can submit the written materials. It seems like you've got something highlighted there and
Yeah, this
whatnot.
is the Supreme Court decision in general, and just full disclosure, I am an attorney, so I can prepare a memo for him.
Yeah, that's
to
fine.
lay this
Well,
out with that and many other cases. I have all the cases regarding Vineyard 48. I'm sure you guys are all familiar with that.
Well, it's a different town, though.
But the SLA reviewed the happenings at the vineyards and stuff like that and cross-referenced it with the agricultural laws. So while it may not be controlling, it would be, persuasive as
Point of
evidence.
reference.
What's that?
As a point of reference.
Exactly, because there, what they did is they ran disco parties and dance parties there. And besides, even though they were violating town sound ordinances between the Ags law and the SLA, none of those events were considered in violation of our license and the Ag laws. And trust me, we're not gonna have anything like that. I don't know if any of you guys have been to the vineyard since I've taken it over. It's totally different than what it used to be. It's a family area. The music volumes are always controlled. I have me and my 4 boys there every weekend. We have our own decibel meter. We walk across the street to our neighbor, and we ask him what he thinks. We have all the speakers in different zones. As a matter of fact, I had a person come to me this week that wanted to do a 200-person wedding out on our back lawn. And I had a handful of conditions, and one of them being that his DJ had to plug into my sound system, so I would have total control. And they refused. So I didn't make an exception for that, because I know what the DJ's music is gonna sound like, it's gonna vibrate the ground probably across the street. So that's not what we're planning on doing, but, people do like to listen to some
I was
music.
thinking about coming to visit, but I found out you're a lawyer, so. I'm on the fence.
Oh, come on,
Sorry,
Ed,
Dick.
come on, Ed, we, all these years and you still say that.
So let us share that with the town attorney. We'll get a better opinion from him, perhaps written, and then, hopefully we'll find some common ground here to keep moving this forward. Is
I
there
mean,
any-
it's a great place now. I mean, I've been there myself.
You've been there since?
Yeah, I live right there.
Oh, okay.
So, and it's quiet. You don't hear the music you heard before, believe me. I stated that at the last meeting.
I first visited in October of 2019, and I can tell you honestly, in a whole day, I don't get the amount of people that he had in that one, because we have people, our average table time is around, an hour and a half to 2 hours. But when I was there, it was like a standing dance party, and they had a full band. The biggest we've had is a 3-person band, and mostly we have just single guitar players or duets. And, I mean, we're trying to make a better name for ourselves there to try to get better clientele. We're trying to get rid of the kids and stuff like that because, we found that they may come in big groups, but they don't spend a lot of money. And they make a lot of loud noise and stuff, so, we're trying to get people, that want to have a nice, relaxing day there, and just, it does require, I believe, to have music. It gets a little quiet if it's not,
Right.
so.
Okay. And Greg, you said you were gonna follow up with Ags and Markets just for an interpretation, or?
Yeah, I mean, some of the stuff in the Ag and Markets law, it's very specific about the amount of income, and there was something specifically.
They want to make sure that more than 51% of my revenue comes from selling wine and not having weddings, which would be pretty simple.
One of the issues, sorry.
Proximity to.
Yes, one of the
neighboring
issues
residences.
raised during the hearing was proximity of the music to Sound Avenue. And I mean, first of all, Cider House and this is totally different. I mean, if you've been to the place, this is a much deeper property.
Cider House is literally
He said, well,
40
if you're
feet
not
from
bothering the
road.
people on Sound Avenue, because we specifically designed it not to project towards Sound Avenue, because if you remember the way it used to be run, there were outdoor tents right behind the existing house, and that was his major draw, right there, because he was using the barns for horses, for, his saving horses, and so he had all of the music and all of the congregation of people between the front building and the barn. This is a new facility specifically designed to bring them back further, right, and into the barn, and on the north side of the barn, and with some, I guess, limited on the west, we have a little bit of area for them to stand on the west.
But that borders
Sit on the west.
Owens Brothers.
So on the west, you have
nursery.
Owens Brothers, which is 816 feet to the nearest residence past Owen Brothers.
Yeah, but what about to the north of the
The
property?
north is 1,900 feet to the closest residence. I can give you the pictures. Yeah.
He'll bring it up to me, thank you.
I need to take the mask off. I don't know if it's one enough height. So they're different. I mean, one of the things in site plan is to try to mitigate noise propagation by providing screens or vegetation or berms. Well, the building's a pretty good screen. That's the concept.
Actually, probably one of the more buffered,
Yeah, it's got a lot of distance between, to the closest house, and to the west, it's got to propagate through the Owen Brothers property, which is not flat.
yeah.
And I'd like to point out that I did notify all the neighbors around us. I got their green cards back. They all received a notice, and not one of them showed up at the hearing. Our good friend Mike Foley showed up, but apparently he shows up at everyone's hearing. So I think we should take that comment with discretion.
So Stan, just to your point, I'm going to quote from this is the guideline for review of local laws affecting farm operations which produce, prepare, and market crops for wine, beer, cider, and distilled spirits. Regarding marketing activities, example, weddings, receptions, parties, and special events. The department considers events to be, quote, incidental only when the gross annual sales from the non-beverage portion of event sales, including any facility rental, vendor fees, admission fees, catering charges, sales of other alcoholic beverages, etc., does not exceed 30% of the total gross sales from the retail sale on-site of the beverages produced on the farm. Then it references those beverages produced on farm need to be at least 51% of on-farm produced grain, hops, grapes, etc. And it does a bookend on that section, and it underlines in bold letters, farm operations must keep sufficient records to prove that this requirement is met. further, local governments can require the farm to submit an annual report to the locality showing that these conditions have been met. So it's not kind of just free reign, it does kind of give the local municipality authority to ask for those records. So I mean, just to get that there.
Okay. I don't know that that would ever happen, but who's gonna police that? Let's be honest.
Well, it's actually pretty easy to do, because as a matter of fact, I just had to prepare a similar report for my insurance company, and they wanted the revenue to be broken down based on, you know, beverage sales and site fees and all that kind of stuff. So it comes right from the POS system. It's not difficult to do.
Hey, Dick, do we have to address the music issue in the site plan? I mean, that could be...
I would say no, but-
I was actually asking, attorney, I knew right now. I don't know if we have to address it.
Well, is he going, does he show facilities for playing music? Is there,
Yeah.
what is the plan?
You just
show?
said you're gonna have outdoor music.
Right, but there's nothing on the site plan indicating, you know, where. It's not part of the plan itself. So just,
Because the speakers, I remember there were speakers on the plan for Cider House.
Okay, so if we-
And he's telling us he has his own sound system. I'm assuming he must have speakers
Right.
associated with the sound system, and they must be part of the site plan.
they must be.
The word "must" is inartful there. One would assume they are shown where they are if they exist as part of what you're proposing to build. I think what the
I think the first.
board member is asking is, must they be shown?
Yeah,
That's what
must they?
that's what he's
No,
asking.
does the issue of music or not music have to be addressed in the site plan? I don't see why it does.
If you approve a plan that shows music-generating facilities, you're approving something that can make music.
But the site plan doesn't have any
I don't
speakers
remember
on
any other
it.
site plan on any.
Well, I do remember the cider.
So that means you're not gonna be playing any outside music.
Well, I will, but, I mean.
So that's where we are.
I think we're
I
clearly,
don't
the
think that's the
gentleman's
question.
asking
I
to,
think Ed's question is do we have to address the fact that there is gonna be outdoor music?
or do you have the authority to address it?
Right.
And I think it was Bob's opinion that since the opinion, in his opinion, didn't address it, you could address it. But if the opinion says it's beyond what you can address, then you can't address it. Which is where we're back to where we started.
I'm not sure.
Yeah, he's here.
I almost don't want to come up, to be honest, but the question was posed to me yesterday whether anything in the stipulation addressed outdoor music, and I think was the way it came to me, which was probably the wrong question. Like everything else, it's the way the issue's phrased. So that's how I responded. Now, with respect to the site plan review, I think underpinning that is seeker analysis. So from a seeker analysis, one of the things you can look at is noise and effect on the neighborhood. So roundabout, I believe that it's something you can examine as part of your seeker review when you're moving the project forward, because seeker does allow you to look at that as an item, and whether that's an environmental concern to you, and whether it's an item that needs to be mitigated. So I think you can do that, and your regulations also talk about if there are items that are identified during your preliminary site plan review, you can have them addressed during your final site plan review. So, and it says items, I think, or criteria or concerns. So it's a generic issue. It does not specifically identify sound, but again, I think under seeker you can look at that. So I'm hoping that helps.
So your opinion was based on the stipulation entered into by Riverhead and the Rubens,
Right.
not the Supreme Court decision that dismissed the cause of action for outside noise.
But it got dismissed because of the break in time and other issues. There's an application that's pending before the board. I'm not even looking at the decision from the court. I'm not looking at the stipulation. I'm looking at it from a more generic standpoint, which is, can the planning board, as part of their site plan review, consider sound? And it's my opinion that you can as part of that underpinning seeker.
Okay.
Don't we already have a negative secret?
I don't know. I
On
don't know
the
where you are
plan?
in the seeker process, so that's my,
Yeah, I mean, we have-
I don't know that answer.
Okay.
Okay.
I'm Jeff Falmuth, I'm the project engineer on this. It is designed to mitigate sign. We relocated the gathering point for people to a new vineyard building. We set the tables and locations for outdoor on the north side of the building, away from Sound Avenue, and some seating is on the west side of the building, separated from the adjacent residence by Owen Brothers. It's almost 900 feet away. Sound dissipates
commercial
with distance,
business.
So it already is designed to mitigate sound. The question is whether or not, he's allowed to have music as
So
incidental.
that's where I am with this, I mean, because
Yeah.
we've asked this question on a
It's
very,
designed
very, basic standpoint, and that is outdoor music allowed along the Sound Avenue corridor without a special permit? That's really the basic question that I have. And maybe,
In the past, we've been told that it's not.
right,
From Sound Avenue, the intersection of Sound Avenue and 25A to Route 48 and Sound Avenue. That's what we've been told in the past. So, but I will agree with this, and let me interject this. Can we move this along and put a subject to, so at least we move this thing along?
Sure.
I think you're looking at me.
I am.
I don't think there's a resolution on this evening.
no,
So we can certainly get the gentleman's input shortly and respond to him shortly and respond to you. I don't think it's intent to hold it up. Is the site plan otherwise completed its review?
well, we just had some questions about,
Is this a
and
pr-
they probably were answered, hours of operation,
Yeah.
parking, bus turnaround, those types of things.
Well, can I just add one point, you guys were under the impression that amplified music was prohibited on the Sound Avenue corridor, and we're not gonna find anything in the town code that says, yes, you can have amplified music on the Sound Avenue corridor, but at the same time, I couldn't find anything that prohibited it, and a town attorney should know the code better than me.
So
I couldn't
we're gonna-
find anything that prohibited specifically to the Sound Avenue corridor. I mean, if you want to direct me to that, I'll definitely address it in my memo.
I think what we'll do is we'll, there's no resolution on today. Maybe you could counsel us on these remaining questions and get back to us prior to the next meeting, whether it's you and Bob and Jefferson on those questions, and then we'll move forward. Okay?
Yes.
All right. Anything else for this application? Nope. All right, thank you.
Was there any other parts of the plans that you wanted to address?
I mean, he did, the applicant did, the question was bus turnarounds. They have on their site plan shown the ability to maneuver a bus.
They had
if it
all
were to
that
pull into the
last time,
site. They demonstrate
Yeah.
turning ability on
Yeah.
that northern parking lot area expansion. So if they did have a bus, I mean, I know they did mention that they're gonna regulate how buses come in or, large parties, but they did demonstrate that a bus could turn around. I believe it would probably be the same for an emergency vehicle if they needed to utilize that space and turn around.
So, at the last hearing, one of the questions is whether or not we could combine our access.
Sir, you gotta speak up there, please. Thank you.
One of the other issues at the hearing, or suggestions at the hearing, is that we somehow combine access through the Owen property. So I asked the owner to address the question with the adjacent owner, Owens, and no.
Yeah, I didn't think they would
I
be
mean,
interested.
it's a nice idea. If both properties were under some type of a site plan, I could see the board requesting it, but we have a letter from them that I can submit.
That's fine. Thank you.
That's all, I don't need all the copies, I don't need all the copies right now. So does that mean I'm not gonna be able to see Metallica at the Vineyard?
No, guarantee that.
All right, thank you.
All right, thank you.
Hopefully we see you again in a couple weeks.
Okay, thank you.
Okay, next item on the agenda is Calverton Solar Energy Center, Nextera. All right, Greg.
So, we do have a final approval resolution on for the Calverton Solar Energy Center Nextera project, located at 149 Edwards Avenue and 2714 River Road, Calverton.
Thank you.
We do have Steve LaSquadro here, attorney representing the application. This board did grant a preliminary site plan approval resolution by Resolution 21-46 dated May 6th of this year. There were a number of conditions in there that the applicant has worked to satisfy. I'll just quickly go through some of those conditions and address how the applicant has addressed them. So to date, if you look on page 6 of the resolution starting, one of the requirements was the necessity for the approval of a stormwater pollution prevention plan. The applicant obtained approval from the town engineer for that SWIP by letter that was dated July 4th, 2021. There was a requirement for a payment in lieu of taxes agreement with the town. That was executed on June 4th, 2021. The requirement for the easement under Edwards Avenue to be executed. Now, I did speak to Bob. That was just, the way I had worded it was somewhat inappropriate. I didn't feel it was appropriate to encumber the Edwards Avenue roadway until the final site plan had been approved. So they did sign a memorandum of understanding regarding the easement across Edwards Avenue, and that will be fully executed upon site plan approval. There was a requirement for the community benefit agreement. That community benefit agreement has been fully signed by both the project sponsor and the town supervisor. That was completed on May 10th of this year. The applicant was required to submit conservation/recreation easement language for the large wooded area on the western portion of the property. They have submitted that. The town attorney did approve the general language, just had some comments regarding either legal descriptions or Schedule A descriptions when they go to file covenants on the property. The planning board required the decommissioning plan be revised. That decommissioning plan has been revised. They submitted it. It's dated May 28th, 2021. And that updated decommissioning estimate has removed any consideration for the sale, salvage, or recycling of the components, as the reality of it is we have no idea what the resale or recycle value or the reuse of this project, the components will be in 30 years from now. The applicant has obtained approval from the Suffolk County Department of Health Services for the abandonment of the existing on-site sanitary systems, which are currently serving the existing clubhouse on the the eastern parcel on Edwards Avenue, as well as the existing dilapidated residence on the western parcel, and they have submitted a landscape maintenance plan. So we do have a final approval. They have addressed those conditions in the preliminary approval resolution. I did receive a memo from Vinnie Gaudiello on the decommissioning plan. He had just brought up that decommissioning plan did not include any escalation or inflation value for the life of the project. So he had wrote a memo that the decommissioning estimate should be revised to include, I believe it was a minimum 15% escalation over the lifespan. And I did include that as a condition of the approval, that prior to the issuance of a CO, which is dictated in our town code, I believe that is required by town code 301-283A6, that it'll need to reflect that 15% inflation cost as recommended by the town's consulting engineer. Do have a number of conditions prior to the signature of Mylars and issuance of building permits. There will need to be some minor revisions to the plans. We did send it to the Pine Barrens. They had some comments. They just wanted some clarification noted on the plans regarding quantification of areas expressed in acres, additional notes identifying the existing trail network that is in that western parcel, in that wooded area, protection measures for areas what I'll call outside the perimeter of the solar fence line. These areas to remain natural and undisturbed. All the existing vegetation is to remain. I did include a condition there. I believe it's number 2 or 3. of the final approval resolution, which states that, no, there's something in there that states that the applicant, if there's any erroneous clearing, if any of those areas to be identified, that they shall be solely responsible for the revegetation of those areas.
19-2.
19? I'm sorry, yeah, 19-2. So if there's any clearing areas, we will have them go out prior to any building permits. They will stake out the fence lines, just so that we can verify the protection of those areas. They'll need to file covenants and, sort of the standard procedural stuff prior to the signature of the Mylars and the issuance of building permits.
Okay. All right, so the escalation was added to the decommissioning plan, and I know you mentioned the Pine Barrens. Do we have their approval at this point, or did they suggest that they were positioned to approve it?
So the memo that I had received the memo from the Pine Barrens earlier this week. I received it on Monday in draft form. I did include the language from the Pine Barrens letter. That letter was voted on by resolution by the Pine Barrens on Wednesday. So that letter is in effect. There are no hardship permits that are required for this. There are no further approvals that are required by the Pine Barrens Commission. They essentially put it into the planning board's hands to obtain compliance and just demonstrate compliance with the project. But
Okay.
the only area of tree removal on this project, I did speak with Dan McCormick in the town attorney's office. We had a phone conference with members of the Pine Barrens Commission staff. The only trees that are being removed on the subject property are in the vicinity of the clubhouse on the mini golf course. Prior, we had aerial images from 1984, which showed that area in the vicinity of the clubhouse in 1984 was a farm field. So those trees and vegetation were planted as part of the site plan approval for the Calverton Lakes Golf Course. That site plan was approved prior to the establishment of the Pine Barrens Commission, prior to the establishment of the comprehensive land use plan. So it's not considered to be natural vegetation. Those were planted as ornamental vegetation related to the golf course.
That's minimal though, right?
Correct.
Okay. All right, do we have any other questions? No? Nothing else, Greg?
Unless there's anything else from the board,
You're in agreement to all the conditions and everything listed in the resolution?
I am, and in fact, there was just clarification on what two specific items meant, and I went over that with Mr. Bergman this afternoon, conveyed that to the client, so we understand what the language actually means, and in fact, he's being gracious enough with respect to one of them to meet the applicant at the site, just so with respect to the area where the fencing will be, that everybody will be in agreement as to how that fence will be placed. So I appreciate his efforts in that regard. I'd also be remiss, apart from thanking the board, of course, for a long and arduous process, that I would express my gratitude to Mr. Murphy and Mr. Kosakevich, who spent a fair amount of time to make sure that the applicant could understand exactly what the requirements of the town code are and how they can best be in compliance with them. So we're grateful for their efforts, as well as the efforts of Mr. Bergman.
Okay. We will vote on this shortly under resolution.
Thank you very much.
Thank you. Okay, so we have no public hearings scheduled this afternoon. Before we do go to the resolutions, are there any comments from the public on the resolutions? Anyone from the public want to comment? Just come up to the podium and please identify yourself.
How you doing? I'm Brian from Manorville. And I've been paying attention to this whole process about the NextEra and solar farms in Calverton. And I'm very disappointed, I guess. You guys well know that, because the fact that an environmental study was not, a current one, wasn't done after the two solar farms on Edwards Avenue were constructed already 10 years ago, and forced all the wildlife from
Sir,
those.
you're talking to the microphone,
Yep,
please.
forced all the wildlife into the Calverton location right now. So the amount of carnage, animal carnage, has not been calculated in any level, hasn't even been brought up. Plus, to this day, I don't know if the board members are informed as far as the chemicals that are in the solar panels. Was there a material data sheet presented to you guys at all? Are you familiar with the chemicals? It's very important that you guys know that because you're actually planning Calverton, Riverhead, the east end of Long Island. About the water contamination, the possibility of water contamination. So everybody wants to protect the water, but this whole plan, not just their plan, but the entire plan is for almost 1,000 acres of solar in Calverton. You're putting a waterbed of encapsulated chemicals above our drinking water and the same water that irrigates our crops for all our farms out here above our drinking water. One disaster, just one hurricane, one hailstorm, one fire, one ice storm that damages those panels and allows those chemicals to soak into our drinking water will damage our drinking water for a long, long time. And these are forever chemicals. They don't go away. They get in your body and they accumulate over time. And I heard so many people say that it's a property owner's right to sell property that he owns. Everybody's for property owner rights. But the problem is, right below that property owner's land is the community water. Nobody's addressed this. Nobody has even thought about what are the possibilities of a damage done by natural disaster or a man-made disaster. What are we going to do to clean up the water? How do you filter those chemicals out of our water supply? There is no filtration devices right now that are current that can filter these chemicals out of the water.
Well,
There
actually are, but I'll let you go on.
There's lead, there's chromium, there's cadmium, there's tellurides, all kinds of forever chemicals that they don't even know how to measure now. There's like 600 chemicals that they don't even know how to measure, much less find or filter. So you're approving a site plan. I know it was the town that took lead agency on it. It's not your fault that it got to this point. But there's a lot of concerned people. They're not coming out. They were not even able to speak out because of the 2 p.m. Tuesday hearings that were done, which nobody has time Tuesday in the afternoon to get on a Zoom call to follow this. So what I'm reaching out to you is, why don't you take some time? Because what's happening is in California, they can't even get rid of the panels that they have. They're stockpiling. And what happens when it stockpiles is Long Island is surrounded by salt water. Anybody that has a car or a boat knows that it corrodes metal. And you're putting these solar panels here for 20, 30 years, it's going to corrode. Where are these chemicals going to go? Nobody's even addressing this. It's like, where's the material data list? I asked the town board members after they approved it, what are the chemicals in the solar panels? They said, if you're interested, you ask. I've asked several times. Nobody knows. Nobody could tell me what chemicals are in these solar panels. They got magic chemicals? I don't know. Maybe they have chemicals that don't affect the water. Who knows? But most solar panels have chemicals that affect our drinking water. So the fires, we have a fireman on the board now, and there's no way to put out a solar fire. It's just going to burn. The chemicals are going to go up in a big cloud of smoke, and the fallout is like 10 miles. So these are going to come down on our crops, our farmlands that are surrounding this area. There's a lot of farms in Calverton. There was no one that addressed this at all during this whole year and a half of project. So, this thing could be rubber stamped for all I know. It could be stamped, approved already today, who knows? But there's got to be some accountability too. If something does go wrong, who's going to be held accountable? Is it the town? Is it the planning board? Is it the solar companies for not addressing? the solar companies actually give people the risk. They give their unit holders, the people that invest in their companies, they give a list of possibilities of things that could happen bad. What are the risks to their investment? The town board never even gave the risks to the town people. This is what could happen. If you have a hurricane, you can have outages for weeks. Who knows? If your grid gets hacked, what happens to the old people in the hospitals when they don't get enough power to be able to keep their heat on in the middle of winter? This isn't Texas. It's not warm. If we go without power in the winter, we're screwed. People are going to die. So I'm just saying, has anybody put any attention on the long range instead of the short-term financial gains from this? That's all. If you guys could live with that decision, if something does happen, a fire, a hurricane, hailstorm, tornado, which we had in Manorville just a year ago, something like that happens to these panels, who's going to be held accountable? Because there will be accountability at that point, because you're going to endanger the lives of those people that are in your community. That should be brought up. Put it on a ballot. Put it in a proposition. Let the people of Calverton and Riverhead make that choice. This shouldn't be done in the cover of COVID. This should be done out in the open. Nobody knows about this. News 12 just found out about this. They're like, what? How come we didn't know about this? So if that's a News 12, if they're finding out about this now, how many other people don't know about this?
Well, there's many more coming.
That's what I'm saying. There's a lot of solar coming. And if you don't address this now, this is the linchpin. There's going to be so much more. And people are going to start finding out. They're opening their eyes. They're seeing more and more of what's going on, and they don't like it. 760 people filled out an online petition to say they don't want it. They don't want commercial solar in California.
So just so you know, Mr. Graham,
Sure.
this board, you mentioned this, we were not the lead agency for this, for the secret process.
Yes,
So
and I don't blame you.
we had little say into all of these issues that you're bringing up. But beyond that, I don't know, I can't remember exactly the date, but perhaps 2 years ago, this board recommended to the town board that they invoke a moratorium on solar. To this day, twice we did it, Joe?
Yeah.
So we don't
I
have the
applaud
authority
you.
to.
I actually applaud you. I'm not here as a crazy person. I applaud for you for actually trying to pay attention to this.
So the reason why I say that is because I kind of, interjected that there's more coming. And that was a concern that this board had 2 or 3 years ago, that we didn't have all of these answers, and these projects were coming in too fast for the town, in our opinion, to wrap their arms around it. But unfortunately, nothing's been done as far as a moratorium, so here we are today faced with this final approval for this project.
And how do we address that, though? How do we?
You have to go to the town board meeting or write them a letter or tell them how you feel. I mean, I think we all know how you feel, but it's really, as far as solar and the updated master plan, I mean, that's where this is right now. I mean, there's another mega project that the town, it's not Article 10, it's the ORIS review now. 94C.
I mean, are the people being informed of this? Because I know for a fact that I know tons and tons of people that don't even know that this even is going down.
Well, they have to follow the code as far as public notification, and to the best of my knowledge, they follow it. They post it where they're supposed to post it. People choose not to come out and speak up. I mean, this particular application did get well vetted here. I mean, we spent many long nights here listening to the public at the hearings for this, not the environmental review portion, but for this. So
Right.
it's, unfortunately, it's where we're at with this project today.
But I was on the Zoom calls, and there was no more than 5 people at 2 p.m. on Tuesdays at these things, because nobody,
Well, when we had ours, we had quite the input from the
Yeah,
public.
well, you guys did. I was on that one too,
Right.
But like the Zoom calls for the town board, 5 people most, and they were all like locals, that were trying to get the town, they were trying to get answers from the town, but you were only able to speak for 5 minutes. You weren't able to have a back and forth because it was on Zoom, so they took your 5-minute statement and said, we'll address that. They don't.
Well,
They don't have to.
your concerns are really gonna wake a lot of people up.
I hope so, because.
Maybe not with this project, but the next one that already got approved by the state, it's massive along Edwards Avenue. And
It's.
I think once the visual impacts of that, come to light, there's gonna be a lot of people complaining
It's
about it.
devastating.
But again, it's really, we did what we could. We suggested to the town board to invoke a moratorium, and it didn't happen for whatever
Some came
reason.
up too, just so you know, last minute, I don't know if you're familiar with it, but there was a letter that was introduced to the town board just today, questioning some ethics or something.
We received that.
Okay, so, it does, why does this have to be rushed? I mean, is there a guide,
Well,
timelines for
We,
the?
we actually, in the applicant's defense on this particular application, this has been dragged out for a very long time. We really wanted to make sure that all of those concerns were, whether we agreed or not, were identified or answered by the town board, and they've been patient. So
Right, they've been
we
patient.
own this
I
vote
get
today.
it, but sometimes, taking the time to do something correctly, like where everything has been answered, is, more important than just rushing through to make somebody happy. If it's a community, these people are relying on you, our representatives, to make sure that you make the right decisions. If they're in danger for the next 30 to 50 years of a possible hurricane,
I think there was one.
if they're in danger for the next 20, 30, 40, 50 years, they don't even have a plan to get rid of the solar panels once they're here. That's a site plan issue. Where are they going?
We have a decommissioning
We have a
plan.
decommissioning
I would
plan.
probably
Yeah,
recommend
what's a
meeting.
decommissioning plan? Does anybody know it?
It's available, if you'd like, I can get you a copy of it.
Where do the panels go? And who's gonna be the company that actually goes and picks up millions of panels over 1,000 acres?
That's why the funds are in place to do that.
The funds are, but is there a company that's actually gonna do it? Because the recycling plant I heard was in Pennsylvania.
That would be very difficult to
30 years to
state
find
30 years in the future.
But as a
Which
businessman,
company-
if you're a businessman, would you take on something that you weren't gonna make any money at? Because there's no money in the recycling of it. They took the silver out of it. There's no money. No company's gonna volunteer to do this, and they gotta get hazmat suits and everything else for millions of panels? It's not even feasible. I mean, just look at the whole thing. I mean, the money could be there, but who's gonna do it? It's gonna be sitting there in Calverton for the next 100 years. Because nobody's gonna do it.
All right,
If
so
you
I'm
don't have
gonna,
a company, then it's not a decommissioning plan, it's just the money set aside to do something, but who's the company? That's why these questions have to be answered. There's gonna be some accountability eventually, because we've had Hurricane Gloria, Hurricane Hugo, Hurricane Andrew, they've had Irma, they've had Maria, Dorian. These are all things that damage solar farms. So it's not like it's impossible to have.
all right, thank you for your comments, Mr. Graham.
You got
Thank
it.
you. Okay, resolutions, number 1 on the agenda, please.
I'll move resolution number 88 from Carlton Solar Energy NextEra, granting final approval for site plan. So moved.
Second.
Okay, we have a motion made and seconded to approve Resolution 88 for final approval for NextEra Solar Energy. So I'm going to vote no on this. Similar reasons to why I voted no on the preliminary. I think there's just been too many questions on this, and I think a lot of the questions are still outstanding, so my vote is no. But I will call the rest of the board. George?
Yes.
Yes. Joe?
Yes.
Joe, yes. Dick?
Yes.
Yes, and Ed?
Yeah, for all the reasons I've stated, I support it, yes.
Okay, so the resolution passes 4-1. Number 2, please.
I'll move Resolution 89, Rosenbaum Beach Stairs, the Chapter 219. So moved.
Second.
Motion made and seconded to approve Resolution 89, Chapter 219 for Rosenbaum Beach Stairs. All in favor? Aye.
Aye.
Opposed? Resolution is approved.
I'll move resolution number 90, which approves the 25 lots, sketch plan approval for 25 lot subdivision.
Second motion.
on Fairview Estates.
Okay, motion made and seconded to approve Resolution 90 for Farmview Estates. And Greg, this is only for the sketch plan, correct?
Correct.
Sketch.
Okay.
Only for sketch plan,
Right.
they'll need to come in with a preliminary plat.
All in favor?
Aye.
Opposed? Resolution's approved.
Before we get to number 91, I would just like to call an amendment off the floor. I did get an email from one of our retained consulting engineers. In the first resolved, that the applicants hereby directed to incorporate and address the following issues into their final environmental impact statement. Number 1 will be amended as follows. FEIS must include the results of soil sampling on the subject property performed in accordance with the New York State Department of Environmental Conservation's DER 10 technical guidance for site investigation and remediation, and applicable regulations of 6 NYCRR Part 375, including sampling locations, dates and methods of sample collection, chain of custody forms for the materials collected, laboratory analytical results, and delineation and estimated volume of any contaminated material identified on site. The FEIS must also include remediation plans as appropriate in accordance with all applicable New York State Department of Environmental Conservation regulations.
Greg, on the agenda, I don't see the public hearing date.
So that I had amended the agenda. The public hearing for Farmview is off. I got a little mixed up with the
Okay.
applications, so. HK Ventures is resolution number 91.
Okay, so just to be clear, this resolution does not approve this project. It only outlines the requirements to complete the final environmental impact statement.
That's correct.
Okay. Did we have a motion in second? I don't remember.
I'll move resolution number 91, setting forth requirements for inclusion for the FEIS of HK Ventures.
Second.
Okay, motion made and seconded to approve Resolution 91 for the FEIS for HK Ventures. All in favor?
Aye.
Aye. Opposed? That is as amended, I should clarify. Resolution is approved. Okay, any public comments on any matter in front of the planning board? Any public comments today? Okay, we don't have the minutes today for August 5th, that's correct, right, Krista? Next meeting is Thursday, September 2nd, 7 PM. And if there's no other business, motion to adjourn?
So moved.
All in favor?
Aye.
Okay, thank you, have a good
Have
night.
a nice weekend, everybody.